So I don't know why two of my colleagues, how they would fashion a clear statement rule that would say when the law says any person can't accept a bribe, that permits the president to do it.
So I agree, Justice Sotomayor, that the way that this court has interpreted statutes that do carve out the president, Justice Kavanaugh asked about this, was very context specific. The Franklin case basically involved a holding that we are highly unlikely to say that the president is an agency, something that the government said would be a peculiar understanding of agency, when the effect of it would be that we would review the president's decisions under statutes for abuse of discretion, which is a very extraordinary thing to do. I think even going back to Marbury, is perhaps a point on which I agree with my friend. Marbury says discretionary acts of the president are not the kind of thing that the court reviews.
All right, could I go back to your brief and going back to what some of my colleagues have asked you? There appears to be some narrowing principles to the concept that the president is subject to all criminal laws in all situations.
Correct.
You agree that if it affects core powers, then he would not be subject to any laws that attempted to limit those core powers,
that is
correct?
Right.
You're defining core powers as those specified by Article 2.
That is essentially correct, yes.
All right. And the only words in the Constitution is that have to do with the president in law is that he shall take care that the law be faithfully executed, correct?
That is right.
Hard to imagine that a president who breaks the law is faithfully executing the law, correct?
He has to execute all of the laws.
Well, Mr. Dreeben, you really, the presidents have to make a lot of tough decisions about enforcing the law, and they have to make decisions about questions that are unsettled, and they have to make decisions based on the information that's available. Do you really, did I understand you to say, well, if he makes a mistake, he makes a mistake, he's subject to the criminal laws just like anybody else? You don't think he's in a peculiarly precarious position?
He's in a special position for a number of reasons. One is that he has access to legal advice about everything that he does. He's under a constitutional obligation he's supposed to be faithful to the laws of the United States and the Constitution of the United States. And making a mistake is not what lands you in a criminal prosecution. There's been some talk about the statutes that are issued in this case. I think they are fairly described as malum in se statutes, engaging in conspiracies to defraud the United States with respect to one of the most important functions, namely the certification of the next president.
Well, I don't want to dispute that particular application of 371, conspiracy to defraud the United States, to the particular facts here, but would you not agree that that is a peculiarly open-ended statutory prohibition, in that fraud under that provision, unlike under most other fraud provisions, doesn't require any impairment of a property interest?
It's designed to protect the functions of the United States government, and it's difficult to think of a more critical function than the certification of who won the election.
Yeah, I'm not, as I said, I'm not discussing the particular facts of this case, but it applies to any fraud that interferes seriously with any government operation, right?
So what the government needs to show is an intent to impede, interfere, or defeat a lawful government function by deception, and it has to be done with scienter. These are not the kinds of activities that I think any of us would think a president needs to engage in order to fulfill his Article 2 duties, and particularly in a case like this one. I want to pick up on something that the court said earlier about the distinction between a public official acting to achieve public ends and a public official acting to achieve private ends. As applied to this case, the president has no functions with respect to the certification of the winner of the presidential election. It seems likely that the framers designed the Constitution that way because at the time of the founding, presidents had no two-term limit. They could run again and again, and were expected potentially to want to do that. So the potential for self-interest would explain why the states conduct the elections. They send electors to certify who won those elections and to provide votes. And then Congress, in a extraordinary joint session, certifies the vote. And the president doesn't have an official role in that proceeding. So it's difficult for me to understand how there could be a serious constitutional question about saying you can't use fraud to defeat that function. You can't obstruct it through deception. You can't deprive millions of voters of their right to have their vote counted for the candidate who they chose.
Thank you, counsel. Justice Thomas? Justice Alito?
Could we just briefly review the layers of protection that you think exists? And I'm going to start with what the D.C. Circuit said. So the first layer of protection is that attorneys general and other Justice Department attorneys can be trusted to act in a professional and ethical manner, right?
Yes.
How robust is that protection? I mean, most of the vast majority of attorneys general and Justice Department attorneys, and we both served in the Justice Department for a long time, are honorable people, and they take their professional ethical responsibilities seriously. But there have been exceptions, right? Both among attorneys general and among federal prosecutors.
There have been rare exceptions, Justice Alito, but when we're talking about layers of protection, I do think this is the starting point. And if the court has concerns about the robustness of it, I would suggest looking at the charges in this case.
Well, I'm going to talk about this in the abstract, because what is before us, of course, does involve this particular case, which is immensely important. But whatever we decide is going to apply to all future presidents. So as for attorneys general, there have been two who were
departments of justice that are staffed by multiple people who do adhere to their office. And Justice Alito, if I could the point that I wanted to make about this case does go to the general proposition. The allegations about the misuse of the Department of Justice to perpetuate election fraud show exactly how the Department of Justice functions in the way that it is supposed to. Petitioner is alleged to have tried to get the Department of Justice to send fraudulent letters to the states to get them to reverse electoral results.
Yeah, I understand that, Mr. Dreeben, but as I said, this case will have effects that go far beyond this particular prosecution. So moving on to the second level of protection that the D.C. Circuit cited, federal grand juries will shield former presidents from unwarranted indictments. How much protection is that?
Well, it affords two levels of protection. One is the probable cause finding requires evidence. I think some of the fears about groundless prosecutions aren't supported by evidence, and they're not going to get out of the starting gate.
I mean, there's the old saw about indicting a ham sandwich.
Yes, but I think just
you had a lot of experience in the Justice Department. You come across a lot of cases where the U.S. attorney or another federal prosecutor really wanted to indict a case and the grand jury refused to do so.
There are such cases. Yes. But I think that the other
Every once in a while there's an eclipse too.
Well, I think that's for the most reason is prosecutors have no incentive to bring a case to a grand jury and secure an indictment when they don't have evidence to prove guilt beyond a reasonable doubt. It's self-defeating.
All right, then the third level is that former presidents enjoy all the protections afforded all criminal defendants, right? And we've discussed that. And that may be true at the end of the day, but a lot can happen between the time when an indictment is returned and the time when the former president finally gets a vindication, perhaps on appeal. Isn't that correct?
It is correct, Justice Alito, but I think that we should also consider the history of this country. As members of the court have observed, it's baked into the Constitution that any president knows that they are exposed to potential criminal prosecution. My friend says after impeachment and conviction, we don't read the impeachment judgment clause that way, but it's common ground that all former presidents have known that they could be indicted and convicted. And Watergate cemented that understanding. The Watergate smoking gun tape involved President Nixon and H.R. Haldeman talking about and then deciding to use the CIA to give a bogus story to the FBI to shut down a criminal investigation.
I mean, you missed.
Feels like a dream, feels like magic. Now I believe I can have it. Taboo, all of my wishes came true. Felt like a billionaire. Felt like a billionaire.
Download the Temu app and shop like a billionaire.
Join me as I take a deep dive into the least consulted ticketing app in history, SeatGeek. Did SeatGeek invent the ticket?
No, but we do make them work.
Drum roll, please. Ooh, how do I use the Seat View feature?
It shows seats with a pole blocking the view. Don't buy those.
What if I want to sit behind the pole?
Buy those.
Join me as I bore you to death with a series of interviews about a ticketing app that just does what it's supposed to do.
Defense that might provide an as-applied Article 2 challenge at the time. I'm not suggesting today, but the idea that a decision that was made and ultimately endorsed by this court, perhaps wrongly, in the Korematsu case, would support criminal prosecution under 241, which requires under United States versus Lanier that the right have been made specific so that there is notice to the president. I don't think that would have been satisfying.
All right, well, we could go through other historical examples. I won't do that. Let me just touch briefly on a couple of other things. One is the relevance of advice of counsel, and I wasn't clear what your answer is. So if the president gets advice from the attorney general that something is lawful, is that an absolute defense?
Yes, I think that it is under the principle of entrapment by estoppel. This is a due process doctrine that we referred to in our brief, our reply brief in Garland versus Cargill this term at page 19, where we cited authority of this court that if a authorized government representative tells you that what you are about to do is lawful, it would be a root violation of due process to prosecute you for that.
Won't that give presidents an incentive to be sure to pick an attorney general who will reliably tell the president that it is lawful to do whatever the president wants to do if there's any possibly conceivable argument in favor of it?
So I think the constitutional structure protects against that risk. The president nominates the attorney general and the Senate provides advice and consent. And these are the sort of structural checks that have operated for 200 years to prevent the kind of abuses that my friend fears going forward as a result of this once in history prosecution.
On the question of whether a president has the authority to pardon himself, which came up earlier in the argument, what's the answer to that question?
I don't believe the Department of Justice has taken a position. The only authority that I'm aware of is a member of the Office of Legal Counsel wrote on a memorandum that there is no self-pardon authority. As far as I know, the department has not addressed it further, and of course this court had not addressed it either.
Well, when you addressed that question before us, are you speaking in your capacity solely as a member of the special counsel's team, or are you speaking on behalf of the Justice Department, which has special institutional responsibilities?
I am speaking on behalf of the Justice Department, representing the United States.
Now, don't you think we need to know the answer to at least to the Justice Department's position on that issue in order to decide this case? Because if a president has the authority to pardon himself before leaving office, and the D.C. Circuit is right that there is no immunity from prosecution, won't the predictable result be that presidents on the last couple of days of office are going to pardon themselves from anything that they might have been conceivably charged with committing?
I really doubt that, Justice Alito. I mean, it sort of presupposes a regime that we have never had except for President Nixon and, as alleged in the indictment here, presidents who are conscious of having engaged in wrongdoing and seeking to shield themselves. I think the political consequences of a president who asserted a right of self-pardon that has never been recognized, that seems to contradict a bedrock principle of our law that no person shall be the judge in their own case. Those are adequate deterrents, I think, so that this kind of dystopian regime is not going to evolve.
All right, let me end with just a question about what is required for the functioning of a stable democratic society, which is something that we all want. I'm sure you would agree with me that a stable democratic society requires that a candidate who loses an election, even a close one, even a hotly contested one, leave office peacefully if that candidate is the incumbent.
Of course.
All right. Now, if an incumbent who loses a very close, hotly contested election knows that a real possibility after leaving office is not that the president is going to be able to go off into a peaceful retirement, but that the president may be criminally prosecuted by a bitter political opponent, will that not lead us into a cycle that destabilizes the functioning of our country as a democracy? And we can look around the world and find countries where we have seen this process, where the loser gets thrown in jail.
So I think it's exactly the opposite, Justice Alito. There are lawful mechanisms to contest the results in an election. And outside the record, but I think of public knowledge, petitioner and his allies filed dozens of electoral challenges, and my understanding is lost all but one that was not outcome determinative in any respect. There were judges that said in order to sustain substantial claims of fraud that would overturn an election result that's certified by a state, you need evidence, you need proof. And none of those things were manifested. So there is an appropriate way to challenge things through the courts with evidence. If you lose, you accept the results. That has been the nation's experience. I think the court is well familiar with that.
Thank you.
Justice Sotomayor?
A stable democratic society needs the good faith of its public officials, correct?
Absolutely.
And that good faith assumes that they will follow the law.
Correct.
Now, putting that aside, there is no fail-safe system of government, meaning we have a judicial system that has layers and layers and layers of protection for accused defendants in the hopes that the innocent will go free. We fail routinely, but we succeed more often than not. In the vast majority of cases, the innocent do go free. Sometimes they don't, and we have some post-conviction remedies for that. But we still fail. We've executed innocent people. Having said that, Justice Alito went through step by step all of the mechanisms that could potentially fail. In the end, if it fails completely, it's because we've destroyed our democracy on our own, isn't it?
It is, Justice Sotomayor, and I also think that there are additional checks in the system. Of course, the constitutional framers designed a separated powers system in order to limit abuses. I think one of the ways in which abuses are limited is accountability under the criminal law for criminal violations. But the ultimate check is the goodwill and faith in democracy. And crimes that are alleged in this case that are the antithesis of democracy, that subvert it, undermine that.
An encouragement to believe words that have been somewhat put into suspicion here, that no man is above the law either in his official or private acts.
I think that is an assumption of the Constitution.
Justice Kagan?
Mr. Dreeben, I want to go through your framework and make sure I understand it. So first, on the small category of things that you say have absolute protection,
Yes.
that they are core executive functions.
Yes.
What are those small categories?
Pardon power,
Pardon, veto.
veto, foreign recognition, appointments. Congress cannot say you can't appoint a federal judge who hasn't received, a certain diploma, or hasn't achieved a certain age. There are a few other powers.
Is Commander-in-Chief?
Commander-in-Chief is on the list, but I want to add to my answer on that Congress has substantial authority in the national security realm. Congress declares war, it raises armies, it has power over the purse. That's more
So
of
that may be viewed as not really in that core set of functions, which nobody has any power but the president over.
Yes, I think that there may be some aspects like directing troops on the field in which the president's power is completely unreviewable.
Okay, now in the next category, where we've left the core set behind,
Yes.
but we're still in the world of official actions, and that's where you say there are various statutory construction rules that might come into play.
Correct.
But you have characterized those as something different from just saying, oh, look, the statute doesn't say the president, therefore it doesn't apply to the president.
That's right.
So I wanted to give you an opportunity to say, how that would look, how that analysis would look in a given case. And in the course of responding to that, I'm sort of thinking of something like the OLC opinion, which says bribery. The president can be tried and convicted of bribery, even in the part of the bribery statutes that do not say the president. Why is that true?
That is true because there is no serious constitutional question that the president needs to engage in bribery in order to carry out his constitutional functions. And the Office of Legal Counsel pointed out that bribery is enumerated in the impeachment clause. So it falls outside of anything that could be viewed as inherent in the need of Article 2 to function.
Do you think the premise of that OLC opinion was that the bribery was simply not official?
No.
Or is the premise that the bribery was official and still the president could be prosecuted for it?
I think that
Colorado has long been championed for wildlife management policies that promote and maintain abundant, healthy, and sustainable wildlife populations. These policies have helped maintain populations for all of Colorado's nearly 1,000 different wildlife species, which have benefited Coloradans across the state. Help make sure these great policies are allowed to continue by keeping these decisions in the hands of the experts. Don't support disastrous ballot box biology.
So if you were to say what the line is in this category, like when it is that the statute should be understood as precluding presidential prosecution, and when it is that the statute should be understood as allowing it, what general principles should guide?
So the general principles, I think, kind of emerge from looking at what the Office of Legal Counsel has done. So, for example, with respect to a federal statute that prohibited appointments to courts of people within certain degrees of consanguinity, the Office of Legal Counsel said this infringes on a very important appointment power of the president, the power to appoint federal judges. It cannot be presumed that Congress intended to do that because it would raise a very serious constitutional question. The president is out. Then there are categories of statutes where the president is in, like, for example, the grassroots lobbying statute. The Office of Legal Counsel wrote an opinion about that, and it said, for the president or other public officials to go out into the world and to promote their programs, that can't be what Congress intended to prohibit. What it did intend to prohibit is using federal funds to gin up an artificial grassroots campaign that gave the appearance of emerging from the people, but it was really top down. And the Office of Legal Counsel said the president and officials who carry out the president's mandates are subject to that statute. So that's a more nuanced one. And the third example that I will give you is the statute that would permit prosecution for contempt of Congress, the Office of Legal Counsel concluded that a good faith assertion of executive privilege as a reason for not providing information to Congress would preclude prosecution because Congress cannot be deemed to have altered the separation of powers in such a manner. I think OLC probably would have gone on to say if Congress tried to do it, it would be deemed unconstitutional. But again, this was a statute that did not specifically name the president. There are only two that do that. So the entire corpus of federal criminal law, including bribery offenses, sedition, murder, would all be off limits if it were taken to the extent that some of the questions have suggested. And for the general principle, does it raise a serious constitutional question? And if so, to what extent? Can it be carved out individually? And there may be some instances where the statutes here could be carved out and a particular act could be found to be protected. Or does the statute across the board in such a wide range of applications, somewhat analogous to overbreadth analysis, infringe on the president's power so that we're going to say that the president is just out?
Now, that set of issues, they seem important and may occasionally be difficult. They also seem not really before us in the way Justice Jackson suggested earlier. What do you do you think they are before us? We should just clear it up. Here it is. We have a case. What else could we do? How should we deal with this? That there are these lingering issues that go beyond the question of whether there's the kind of absolute immunity that the former president is invoking.
So I think the court has discretion to reach that issue, even though Justice Jackson is totally right. It was not raised in the district court, and it was not raised in the Court of Appeals. And the analysis that I would use to get there is a fusion of a couple of principles. One is the court has often resolved threshold questions that are a prerequisite to an intelligent resolution of the question presented. So in a case like United States versus Grubbs, for example, the court reached out to decide whether anticipatory warrants are valid under the Fourth Amendment before turning to the question whether the triggering condition for an anticipatory warrant had to be in the warrant. So that's one principle. And then a precedent that bears some analogy to this is Vermont Natural Resources Agency versus United States ex rel Stevens. It was a qui tam case, and the first question was whether a state agency was a person within the meaning of the False Claims Act, and the second question was whether if the state agency was 11th Amendment immunity kicked in, and the court wrote an analysis of why it could reach both questions. The reaching the person question didn't expand the court's jurisdiction, and it made sense as a matter of constitutional avoidance to do that. There are some considerations that cut against this, and I want to be clear that for overall government equities, we are not wild about parties who raise an immunity case that can be presented to a court on an interlocutory appeal and then smuggling in other issues. So we would want to guide the court not to have an expansive approach to that issue. But the final thing that I would say about this is part of our submission to this court is that the Article 1 branch and the Article 2 branches are aligned in believing that this prosecution is an appropriate way to enforce the law. Congress, by making the law, the current executive by deciding to bring it. And since a building block of that submission is that Congress actually did apply these criminal laws to official conduct, the court may wish to exercise its discretion to resolve that issue.
Okay, I have one last set of questions, which has to do with the official unofficial line.
Yes.
And you heard Mr. Sauer's responses to both Justice Barrett's questions and my questions about what he thinks counts as official here and what he thinks counts as unofficial here. And I'm just wondering what you took from his responses and also how you would characterize what is official and what is not official in this indictment.
So I think petitioner conceded that there are acts that are not official that are alleged in the indictment, and we agree with him on all of that. I think I disagree with him on everything else that he said about what is official and what is not. Organizing fraudulent slates of electors, creating false documentation that says, I'm an elector, I was appointed properly, I'm going to send a vote off to Congress that reflects that petitioner won rather than the candidate that actually got the most votes and who was ascertained by the governor and whose electors were appointed to cast votes. That is not official conduct. That is campaign conduct. And I think that the D.C. Circuit in the Blassingame case did draw an appropriate distinction. A first-term president who's running for re-election can act in the capacity as office seeker or office holder. And when working with private lawyers and a private public relations advisor to gin up fraudulent slates of electors, that is not any part of a president's job. So
there's an allegation in the indictment that has to do with the removal of a Justice Department official. Is that core protected conduct?
We don't think that that's core protected conduct. I don't think that I would characterize that episode quite that way. We do agree that the Department of Justice allegations were a use of the president's official power. In many ways, we think that aggravates the nature of this offense. Seeking as a candidate to oust the lawful winner of the election and have oneself certified with private actors is a private scheme to achieve a private end, and many of the co-conspirators alleged in the indictment are private. But for an incumbent president to then use his presidential powers to try to enhance the likelihood that it succeeds makes the crime, in our view, worse. And so in the Department of Justice episode, this occurs very late in the election cycle after many other schemes had failed. And at that point, the petitioner is alleged to have tried to pressure the Department of Justice to send false letters to the states claiming that there were serious election irregularities and that they should investigate who they certified as the president. None of this was true. The Department of Justice officials all said, this is not true. We are not going to do that. And at that point, petitioner is alleged to have threatened to remove the Department of Justice officials who were standing by their oath and replace them with another person who would carry it out. We're not seeking to impose criminal liability on the president for exercising or talking about exercising the appointment and removal power. No, what we're seeking to impose criminal liability for is a conspiracy to use fraud to subvert the election, one means of which was to try to get the Justice Department to be complicit in this. The case would have been no different if petitioner were successful and he had actually exercised the appointment and removal power and it had gone through and those fraudulent letters were sent. It would have made the scheme more dangerous, but it would not have changed the crime.
And how do we think about things like conversations with the vice president? In other words, things that if you say it that way, it's clear that they would fall under executive privilege, but how does that relate to the question that we're asking here?
So this is one of the most difficult questions for the Department of Justice, and I want to explain why that is. If we are operating under a Fitzgerald versus Nixon lens and looking at this the way that we look at things when there is a private lawsuit filed against the president, we take a very broad view of what the outer perimeter of official presidential action is in order to be as protective of the president against private lawsuits that, as this court explained in Nixon versus Fitzgerald, can be very deleterious to the president's conduct of business. So if we were putting this under a Fitzgerald lens, we would then have to answer to the question, was he acting in the capacity as office seeker, or was he acting in the capacity as office holder? And if you run through the indictment, you can find support for those two characterizations. And the Department of Justice has not yet had to come to grips with how we would analyze that set of interactions.
Thank you.
Justice Gorsuch?
If you did, though, I just wanted to confirm, I thought I heard you thought that the Blassingame framework was the appropriate one. Is that right?
Largely, yes, Justice Gorsuch. We agree with the idea of the distinction between office holder and office seeker. We also agree that if it's objectively reasonable to view the activities as those
$7,500 summer savings on Lucky.
Facts of that case might be appropriate.
Can you give me an example of what you have in mind? I'm just trying to understand what nuance you're suggesting.
So Blasingame adopted a generally very favorable pro-government framework that we endorse in private civil cases. Yeah. Okay, not here, because we don't think that Fitzgerald applies in the criminal context.
No, I understand that, okay. but putting that aside, the distinction between official act and private office seeker.
Yes.
Their test is, you think, good enough for government work?
On this one, the department hasn't taken a next step since the Blasingame decision, but let me offer a few thoughts that Justice Gorsuch I think might clarify it. The Blasingame decision focused on objective contextual indications to try to see whether the president was acting as a campaigner as opposed to an office holder. I think that decision can also be made by looking at what the president actually said. And let me illustrate that with an allegation that I think my friend talked briefly. That in one of the interactions between petitioner and a state official, petitioner is alleged to have said, all I needed you to do is to find me 11,000 votes and change. I think if you look at that content, it's pretty clear that petitioner is acting in the capacity as office seeker, not as president, and we would look at that content.
Okay. But the test, I'm just focused on the legal test.
Correct.
I'm not hearing any objections to it.
Other than I think that the D.C. Circuit placed more content consideration off limits than I would.
Okay. All right. And then I wanted to understand on the core immunity, or whatever word we use, that it seems to me that we're narrowing the ground of dispute here considerably. Do we look at motives, the president's motives for his actions? I mean, for example, he has lots of war powers, as we've discussed, but he might use them in order to enhance his election, his personal interests. Is that a relevant consideration when we're looking at core powers?
So I am thinking of this more as looking at the objective of the activity as opposed to the kind of subjective motive in the sense that Your Honor is talking about. I think that there is a lot of concern about saying an electoral motive to be reelected such.
Every first-term president, everything he does can be seen through the prism, by critics at least, of his personal interest in re-election.
Yes.
And so you wouldn't want that. I think you would say personal motivations off limits with respect to the core powers.
Probably, well, with respect to the core powers, we think those are just things that can't be regulated at all, like the pardon power and veto.
Right, regardless of motive.
Correct.
Regardless of
That's
motive.
right.
Okay.
That is right.
All right, so then we're in the non-core powers,
right,
where we're fighting over. What role do motives play there? I mean, one could remove an appointee that, well, first of all, maybe ask this first, is removing an appointee, a presidential appointee, a core power or a non-core power in your world?
So here I might need to differentiate between the principal officers that this court in cases like Myers and Seal of Law has regarded as having a constitutional status of being removable at will from inferior officers where Congress does have some regulatory latitude to impose restrictions on removal.
Sure.
And a restriction,
put that aside, yeah, I understand that.
Putting that aside, yes, appointing a principal officer is a core power. I am not prepared to say that there is no potential criminal regulation to say you can't do it for corrupt purposes, to enrich yourself, for example.
Well, bribery, all right, yes. but that's what I was wondering. Do motives come into the core power analysis or not? And now I'm hearing, I thought I heard no, and now I'm hearing maybe.
I think maybe might be a little bit more appropriate because it's not involved in this case. The department has not had to take a position on exactly how these core powers would be resolved under an as-applied constitutional analysis. None is involved in this case.
And I guess I'm wondering, and I'm not concerned about this case so much as future ones too, yes, but these non-core powers and maybe yes, core powers where a president is acting with, at least in part, a personal interest in getting reelected. everything he does.
Yeah.
He wants to get reelected. And if you're allowing in motive to color that, I'm wondering how much is left of either the core or non-core powers.
So I would be fine with carving that out and deeming that to be something that's intrinsic in our electoral system. We're not talking about applying criminal law to somebody who makes an announcement that this program will be good for the United States, and somebody could come along and say, well, you really did it to get reelected. Leaving aside whether any of that violates a criminal law, I know that the next question is assume that it does. I'm doubtful that it in fact does, because I don't think criminal laws generally operate on motives as opposed to objectives and purposes. But
all right, intentions. I mean, you frame a motive as an intention, and intentions as a motive, as you well know, every day of the week.
Yes.
So let's put that aside, too.
I understand. We're putting that aside. That really, to me, falls in a very different category, and it is also possible.
So there's some motives or intents that are cognizable, and others that aren't. I mean, it's awkward, right? When we look back at like the injunction, back to Marbury in the early cases, you can't enjoin a president.
Yeah.
Also, you couldn't hold him in contempt. Right.
A sitting president.
For sure.
Justice Gorsuch, right. Can I try one more time?
Well, let me just spin this out just a second, okay. Right? And it didn't matter what the president's motives were. We're not going to look behind it.
Right.
And same thing in Nixon. We said, gosh, Nixon versus Fitzgerald, that's something courts shouldn't get engaged in, because presidents have all manner of motives. And again, I'm not concerned about this case, but I am concerned about future uses of the criminal law to target political opponents based on accusations about their motives, whether it's re-election or who knows what corrupt means in 1512, right? We don't know what that means. Maybe we'll find out sometime soon. But the dangerousness of accusing your political opponent of having bad motives, and if that's enough to overcome your core powers or any other limits, reactions, thoughts.
Yeah, so I think that you're raising a very difficult question.
That's the idea, right? I mean,
that is the idea.
Testing the limits of both sides' arguments.
And I'm going to say something that I don't normally say, which is that's really not involved in this case. We don't have bad political motive in that sense.
I understand that. I appreciate that, but you also appreciate that we're writing a rule for the ages.
Yes, and I think I would start by looking at the statutes and then seeing what restrictions they do place on the president's conduct. And for example, the statute that prohibits fraud to defeat the lawful functions of the United States. The statute defines what the purpose is that the defendant has to have in mind. It has to be to defeat something that the United States is doing, and it has to be by deception. I don't think that that gets us into the realm of motive hunting in the area where we are as concerned, I think, as the court would be about doing something that would undermine the presidency and the executive branch. And 1512C2, we may have different views on the clarity and the scope of that statute. I think if the court does interpret corruptly as involving a consciousness of wrongdoing and elevates that to consciousness of illegality, then we're in a different realm. Wanting to get reelected is not an illegal motive, and you don't have to worry about prosecuting presidents for that.
Yeah. Okay. Thank you, Mr. Creep.
Justice Kavanaugh?
As you've indicated, this case has huge implications for the presidency, for the future of the presidency, for the future of the country, in my view. You've referred to the department a few times as having supported the position. Who in the department? Is it the president, the attorney general?
The Solicitor General of the United States. Part of the way in which the special counsel functions is as a component of the Department of Justice. The regulations envision that we reach out and consult, and on a question of this magnitude that involves equities that are far beyond this prosecution as the questions of the court.
So it's the Solicitor General?
Yes.
Okay. Second, like Justice Gorsuch, I'm not focused on the here and now of this case. I'm very concerned about the future. And I think one of the court's biggest mistakes was Morrison versus Olson. I think that was a terrible decision for the presidency and for the country. And not because there were bad people who are independent counsels, but President Reagan's administration, President Bush's administration, President Clinton's administration were really hampered, in their view, all three, by the independent counsel structure. And what I'm worried about here is that was kind of, let's relax Article 2 a bit for the needs of the moment. And I'm worried about the similar kind of situation applying here. That was a prosecutor investigating a president in each of those circumstances, and someone picked from the opposite party, the current president, usually was how it worked. And Justice Scalia wrote that the fairness of a process must be judged on the basis of what it permits to happen, not what it produces in a particular case. You've emphasized many times regularity of the Department of Justice. And he said, and I think this applied to the independent counsel system, and it could apply if presidents are routinely subject to investigation going forward. One thing is certain, however, it involves investigating and perhaps prosecuting a particular individual. Can one imagine a less equitable manner of fulfilling the executive responsibility to investigate and prosecute? What would the reaction be if, in an area not covered by the statute, the Justice Department posted a public notice inviting applicants to assist in an investigation and possible prosecution of a certain prominent person? Does this not invite what Justice Jackson described as picking the man and then searching the law books or putting investigators to work to pin some offense on him? To be sure, the investigation must relate to the area of criminal offense specified by statute, but that has often been, and nothing prevents it from being very.
A proposed hunting ban on mountain lions and bobcats in Colorado would allow these populations to go unchecked across the state. This unchecked growth poses risks to other wildlife populations, livestock, pets, and people. Let's keep wildlife management policies in the hands of the experts and protect Colorado's wildlife from dangerous measures. Don't support disastrous ballot box biology proposals.
That emphasized independence at the expense of accountability. We don't have that regime now, but even under that regime, Justice Kavanaugh, I think if you look at Lawrence Walsh's report on Iran-Contra, I think this goes to a very fundamental point for the court to consider. Judge Walsh said, I investigated these matters. The proof did not nearly come close to establishing criminal violations. So we've lived from Watergate through the present, through the independent counsel era with all of its flaws, without these prosecutions having gone off on a runaway train.
Well, I think President Reagan, President Bush, and President Clinton, whether rightly or wrongly, thought contrary to what you just said.
I think nobody likes being investigated for a crime, but it didn't result in the kind of vindictive prosecutions that I think Your Honor is raising as a possibility.
Yeah.
We have a different system now. I think there was a consensus throughout Washington that there were flaws in the independent counsel system. It lapsed. We now are inside the Justice Department with full accountability resting with the Attorney General. So the special counsel regulations now don't operate the way that the independent counsel regulations do. And this court would have something to say about it, I think, if the independent counsel statute were revived. I'm not sure that anybody is in favor of that.
Right. Now, I was just saying this is kind of the mirror image of that as one way someone could perceive it. But I take your point about the different structural protections internally. And like Justice Scalia said, I do not mean to suggest anything of the sort in the present case. I'm not talking about the present case, so I'm talking about the future. Second, another point, you said, talked about the criminal statutes. It's very easy to characterize presidential actions as false or misleading under vague statutes. So, President Lyndon Johnson, statements about the Vietnam War. Say something's false. Turns out to be false that he says about the Vietnam War. 371 prosecution after he leaves office?
I think not, but this is an area that I do think that merits some serious and nuanced consideration. Statements that are made by a president to the public are not really coming within the realm of criminal statutes. They've never been prosecuted. I realize that the court can say, well, what if they were? And then I think you get to what I would regard as a hard constitutional question that would probably guide the court away from trying to resolve today, although I do think it's very different from our case and distinguishable in important ways. But you're dealing here with two branches of government that have a paramount interest in the integrity and freedom of their interactions with each other. On the one hand, the president, of course, should be very free to send usually his cabinet officials and sub-cabinet officials to testify to Congress, to provide them with the information needed to enact legislation and to make national policy. And we're very concerned about anything that would trammel that. On the other side of the equation, Congress has a compelling interest in receiving accurate information, and at the very least, not information that is intentionally and knowingly false. That would pollute the legislative process.
How about, I think it came up before, President Ford's pardon? Very controversial in the moment.
Yes.
Hugely unpopular, probably why he lost in '76.
Yes.
Now looked upon as one of the better decisions in presidential history, I think, by most people. If he's thinking about, well, if I grant this pardon to Richard Nixon, could I be investigated myself for obstruction of justice on the theory that I'm interfering with the investigation of Richard Nixon?
So this would fall into that small core area that I mentioned to Justice Kagan and Justice Gorsuch of presidential responsibilities that Congress cannot regulate.
How about President Obama's drone strikes?
So the Office of Legal Counsel looked at this very carefully and determined that, number one, the federal murder statute does apply to the executive branch. The president wasn't personally carrying out the strike, but the aiding and abetting laws are broad. And it determined that a public authority exception that's built into statutes and that applied particularly to the murder statute because it talks about unlawful killing, did not apply to the drone strike. So this is actually the way that the system should function. The Department of Justice takes criminal law very seriously. It runs it through the analysis very carefully with established principles. It documents them, it explains them, and then the president can go forward in accordance with it. And there is no risk of prosecution for that course of activity.
Thank you for your answers.
Justice Barrett?
Mr. Dreeben, I want to pick up with that public authority defense. So I'm looking at the OLC memo that David Barron wrote that you cited in your briefs. And he describes the public authority defense citing the model penal code. There are a few different definitions, but I'll just highlight this one. Justifying conduct which is required or authorized by the law defining the duties or functions of a public officer, the law governing the armed services or lawful conduct of war, or any other provision of law imposing a public duty. That sounds a lot like dividing a line between official and private conduct. I think it's narrower, and I recognize it's a defense, not an immunity. But when you look at the definition of it, are you acting within the scope of authority conferred by law or discharging a duty conferred by law? I think it's narrower than Blasingame, narrower than Nixon versus Fitzgerald, but that's what it sounds like to me. Do you agree or disagree?
You know, Justice Barrett, I certainly understand the intuition that when you act outside of your lawful authority, you've kind of gone on a frolicking detour, you're no longer carrying it out. I don't really think that that quite works for presidential activity. The only way that he could have implemented the orders is by exercising his commander-in-chief authority over the armed forces or his authority to supervise the executive branch. Those seem like core executive acts to me. There is such a possibility as an unlawful executive act.
I'm not sure that I understand your answer. I mean, I was thinking, it seemed to me that in your briefs and today, when you referred to the public authority defense, you said that's one of the built-in protections and why immunity is not necessary. Because in some of these instances, when the president takes such actions that, you know, the court's been asking you, might this result in criminal prosecution? You say, well, he could raise this public authority defense. And so I'm saying, isn't this public authority defense, if raised, doesn't it sound like a defense that says, well, I was authorized by law to discharge this function.
And therefore, I acted lawfully.
Therefore, I acted lawfully and I'm not criminally liable.
Correct.
Does that involve a look into motives? Kind of gets to what Justice Gorsuch was asking you. Could you say I was acting within the scope of my authority by granting a pardon, removing a cabinet officer, but then the public authority defense might not apply because you had a bad motive in doing so?
No, I don't think so, Justice Barrett. I think that it operates based on objective facts disclosed to counsel. Counsel then provides the advice, in this case, the Department of Justice, and it's an objectively valid defense. It's a complete defense to prosecution.
So what would be so bad? I mean, one thing that strikes me as different, well, one thing that's obviously different between the public authority defense and immunity is an interlocutory appeal and having it resolved at the outset. What would be so bad about having a question like that resolved at the threshold, having it be an immunity? The same kind of question that could be brought up as a defense later, but have it be brought up at the threshold as an immunity, and then an interlocutory appeal would be available, and it would be a freedom from standing trial, but not a get out of jail free card.
Yes, I understand that, and I think that if the court believed that that was the appropriate way to craft presidential protections, it has the authority to craft procedural rules that implement its Article 2 concerns. That said, public authority we're calling it a defense, but under many statutes it's actually an exception to liability itself. And what you're really talking about is trying the general issue. And generally in criminal cases, even cases that involve First Amendment issues like threat statutes, the jury is the determinant of the facts. And I have a little bit of difficulty with the idea of trying the whole public authority issue separately to the judge and having that go up on interlocutory appeal with review of facts before you could ever get it forward into a criminal case. That said, if I would prefer a regime in which the court altered some of the procedural rules surrounding the president than a total, absolute blanket immunity that takes away the possibility of criminal prosecution, even if it was a core violation of the statute in the teeth of Attorney General advice and has no overriding public purpose.
You think it has to be a jury question? And let's see, I wasn't necessarily proposing actually treating it as a defense that was done at the outset and then subject to interlocutory appeal. I was proposing, what about an immunity doctrine that drew from the public authority defense that the Department of Justice thinks would otherwise apply? So just go with me on that for a minute. Why would it be so bad for it not to be a jury question? I mean, it seems to me that some of these Article 2 concerns would be exacerbated by having it go to a jury rather than a judge.
So I think some of them are judge questions that could be resolved on the face of the indictment. If the Department of Justice ever returned an indictment that said the issuance of this pardon or this series of pardons constituted obstruction of justice, I have a little difficulty hypothesizing it, but a motion could be made on the face of the indictment that says Article 2 precludes Congress from regulating these activities. The indictment needs to be dismissed. And if the court wished to attach to that kind of a rule interlocutory appeal, then that would be a lesser safeguard than the one that my friend is proposing here. Other kinds of defenses, though, really do intersect with the general issue. And for those, I have a much greater time seeing how the court could implement that. And would there be costs in going to trial? Yes. There is no perfect system here. We are trying to design a system that preserves the effective functioning of the
Let me ask you about state prosecutions, because if the president has some kind of immunity that's implicit in Article 2, then that immunity would protect him from state prosecutions as well. A lot of the protections that you're talking about are internal protections that the federal government has, protections in the Department of Justice, which obviously are not applicable at the many state and local jurisdictions across the country. What do you have to say to that?
So that raises a supremacy clause issue, and the court would run a supremacy clause analysis that would probably start with basic principles like McCulloch versus Maryland. The states do not have the authority to burden federal functions, and would then kind of move through in Re-Nagel, where the court said that a state murder prosecution of a federal official guarding a Supreme Court justice and who fired a shot was not permissible. If the court thought that you needed a more categorical rule for the states, I think the supremacy clause certainly leaves it within the court's prerogative to determine that the president, unlike all other officials, deserves more of a robust federal defense than what I have just described.
But it would still be a defense in the states. It wouldn't be, I mean,
well,
that's my point. Like, it's one thing to say, well, the president, they're not going to be these prosecutions that are politically motivated, the things that Justice Kavanaugh was referring to that might be the danger of this system, one thing that we have to worry about. That might not carry the day, but, that's a concern. It's totally different when you take it outside of the Department of Justice and its structures, and then you throw it out elsewhere. The idea across the states, the idea of an immunity, I think, has a lot more purchase if you're talking about something that protects the former president from standing trial and the state and local level.
So I don't know that you would have to design a system in which the president would have to stand trial at the state and local level. It's certainly within the court's authority as a matter of supremacy clause law to find an immunity. But we have been talking here about at some length on the distinction between official acts and private acts.
Yeah.
That will have to be determined by some sort of a process. Any immunity defense that the court announces can still be met by a state assertion that we're prosecuting private conduct. You're going to have some process. I think having some legal process is not a reason to cast aside a nuanced system that actually looks at what protections are necessary as opposed to what would provide the absolute maximum insulation for former presidents, even if we acknowledge that it's highly prophylactic.
Totally agree, and I wasn't actually contrasting the absolute immunity rule. I was saying that if there was some sort of official private, there are consequences towards about making immunity. Okay, and since you bring up the private acts, this is my last question. So I had asked Mr. Sauer about on page 46 and 47 of your brief.
Yes.
You say, even if the court were inclined to recognize some immunity for a former president's official acts, it should remand for trial because the indictment alleges substantial private conduct.
Yes.
And you said that the private conduct would be sufficient.
Yes.
The special counsel has expressed some concern for speed and wanting to move forward. So, the normal process, what Mr. Sauer asked, would be for us to remand if we decided that there were some official acts immunity, and to let that be sorted out below. It is another option for the special counsel to just proceed based on the private conduct and drop the official conduct?
Well, two things on that, Justice Barrett. First of all, there's really an integrated conspiracy here that had different components as alleged in the indictment. Working with private lawyers to achieve the goals of the fraud, and as I said before, the petitioner reaching for his official powers to try to make the conspiracies more likely to succeed. We would like to present that as an integrated picture to the jury so that it sees the sequence and the gravity of the conduct and why each step occurred. That said, if the court were to say that the fraudulent elector scheme is private, reaching out to state officials as a candidate is private, trying to exploit the violence after January 6th by calling senators and saying, please delay the certification proceeding, is private campaign activity. We still think, contrary to what my friend said, that we could introduce the interactions with the Justice Department, the efforts to pressure the vice president, for their evidentiary value as showing the defendant's knowledge and intent, and we would take a jury instruction that would say, you may not impose criminal culpability for the actions that he took. However, you may consider it insofar as it bears on knowledge and intent. That's the usual rule with protected speech, for example, under Wisconsin versus Mitchell. My friend analogizes this to the speech or debate clause, but we don't think the speech or debate clause has any applicability here, except very explicit constitutional protection that says senators and representatives shall not be questioned in any other place. So it carries an evidentiary component that's above and beyond whatever official act immunity he is seeking. And the last thing I would say on this is we think that the concerns about the use of evidence of presidential conduct that might otherwise be official and subject to executive privilege is already taken care of by United States versus Nixon. That balances the president's interest in confidentiality against the need of the judicial system for all available facts to get to the truth. And once that has been overcome, we submit that the evidence can be used even if culpability can't rest on it.
Thank you.
Justice Jackson?
Just to pick up where Justice Barrett left off, I think I heard you say that even if we decide here something, a rule that's not the rule that you prefer, that is somehow separating out private from official acts and saying that that should apply here, there's sufficient allegations in the indictment, in the government's view, that fall into the private acts bucket that the case should be allowed to proceed.
Correct.
Because in an ordinary case, it wouldn't be stopped just because some of the acts are allegedly immunized, even if people agree that some are immunized. If there are other acts that aren't, the case would go forward.
That is right.
All right. Going back to the clear statement argument, I'm struggling with that argument because my understanding was that when a charged criminal statute is read narrowly in the presidential context to not apply to the president, a constitutional question is being avoided. So that you're doing that to avoid having to deal with the constitutional question. So what is the constitutional question that is being avoided in those kinds of situations?
A serious one. This is just an application of this court's ordinary construction of criminal statutes, that if there is an available interpretation that would avoid a serious constitutional question, the court's preference is to...
Right, and the nature, I guess I'm going at, my understanding is that what is being avoided in that situation is the question of whether a former president or can be held criminally liable for doing the alleged act that is being asserted in that statute consistent with the Constitution. So we look at the statute, it's got some elements in it, and we are saying, well, geez, if this statute and those elements apply to the president's conduct in this situation, we'd have to answer the question, can the president be held liable consistent with the Constitution for that behavior? Is that right?
So the first step in that analysis, I just want to...
Yes,
but the first step is there ambiguity? And these statutes apply to any person. They apply to whoever. There's no ambiguity in those phrases. This court in Nardone versus United States concluded that similar words, any person, apply to government officials.
All right, well, let's just assume that I guess I'm just trying to get at, we're avoiding a constitutional question if we do that in the ordinary case. And what's confusing to me about this case is that we're not being asked to avoid the constitutional question. In fact, the question of whether or not the president can be held liable consistent with the Constitution or does he have immunity is the question that's being presented to us. So I don't understand how the clear statement kind of analysis even works. It seems completely tautological to me for us to hold that presidents cannot be prosecuted under any criminal statute without a clear statement from Congress to avoid the question of whether or not the Constitution allows them to be prosecuted. We'd have to have a reason, right? I mean, we'd have to have a rationale for applying the clear statement rule.
I think the court would have to have some rationale that's not evident in either the existing doctrine or the text. And just one data point for the court in thinking about how the clear statement rule works. In United States versus Sun Diamond, a case about gratuities that the court is probably familiar with, Justice Scalia wrote an opinion for a unanimous court in which he used a hypothetical about what would happen if the president received a sports replica jersey at a typical White House event. Would that violate Section 201C? And the court offered a construction that it had to be for because an official act to avoid that problem. I think if there was such a well-received understanding that presidents are not included in general federal criminal law, unless the president is specifically named, which he is not in Section 201. Justice Scalia would have thought of that, and some member of the court would have reacted, and none did.
All right, let me go on to ask about what you take the petitioner's position to be in this case, because we've had a lot of talk about drawing the lines. Justice Kavanaugh, Justice Gorsuch suggested that we should be thinking about blasting game, and that within first we have private versus official, and then within official now we have something about core acts versus other acts as we try to figure out, at what level the president is going to have immunity. But I took the petitioner's argument in this case not to be inviting us to engage in that kind of analysis. I thought he was arguing that all official acts get immunity. And so I didn't understand us to be having to drill down on which official acts do. And so my question is, why isn't it enough for the purposes of this case, given what the petitioner has argued, to just answer the question of whether all official acts get immunity?
That is enough, and if the court answers that question the way that the government has submitted, that resolves the case. I want to make a clarification that I may have left the court with some uncertainty.
Whether it's a last-second bake sale, Taco Tuesday, or a meal for your future in-laws, it's going to be great. With McCormick by your side for over 130 years, it's going to be great.
We gotta sell our houses, don't worry. Sell with confidence to Open Door. Request a cash offer at opendoor.com.
Everything that's official in the outer perimeter is not subject to liability.
That is right.
And so we don't have to then go, well, okay, we have the bucket of official, now let's figure out which within that might be subject to liability, not on the theory of absolute immunity, correct?
Neither on the theory of absolute immunity or on our theory. On his theory, everything's protected. On our theory, there is no immunity. But this is where I would draw the distinction. There are as-applied constitutional challenges that you run through the Youngstown framework and this court's customary method of analysis, and you determine whether there's a infringement of Article 2.
So what you're saying is, even if we reject the absolute immunity theory, it's not as though the president is, doesn't have the opportunity to make the kinds of arguments that arise as at the level of, this particular act or this particular statute has a problem in retrospect. I think I hear you saying we should not be trying to, in the abstract, set up those boundaries ahead of time as a function of sort of blanket immunity, allow each allegation to be brought, and then we would decide in that context.
Yes, with the additional note that petitioner has never made that argument, and I think it would be up to a district court to decide whether to go that route at this point in the litigation. He's put all of his eggs in the absolute immunity basket.
All right, and if we invite, if we see the question presented as broader than that, and we do say let's engage in the core official versus not core and try to figure out the line, is this the right vehicle to hammer out that test? I mean, I'd understood that the most, if not all, but most of the allegations here, there's really no plausible argument that they would fall into core versus not, such that they are immune.
We don't think there are any core acts that have been alleged in the indictments that would be off limits as a matter of Article 2.
So if we were going to do this kind of analysis, try to figure out what the line is, we should probably wait for a vehicle that actually presents it in a way that allows us to test the different sides of the standard that we'd be creating, right?
I don't see any need in this case for the court to embark on that analysis.
All right, the final sort of set of questions that I have to do with what I do take as a very legitimate concern about prosecutorial abuse, about future presidents being targeted for things that they have done in office. I take that concern. I think it's a real thing. But I wonder whether some of it might also be mitigated by the fact that existing administrations have a self-interest in protecting the presidency, that they understand that if they go after
the former guy. Soon they're going to be the former guy, and they will have created precedent that will be problematic. So I wonder if you might comment on whether some of the caution from the Justice Department and the prosecutors and whatnot comes from an understanding that they will soon be former presidents as well.
I think absolutely, and I would locate this as a structural argument that's built into the Constitution itself. The executive branch, I think as this court knows, has executive branch interests that it at times asserts in opposition to Congress so that the proper functioning of the president is protected. And I believe that that value would be operative and is operative in anything as momentous as charging a former president with a crime.
And I would also say, I think, and ask you to comment on, presidents are concerned about being investigated, evaded, and prosecuted, and it chills to some extent their, ability to do what they want in office. And that's a concern on one side, but can you comment on the concern about having a president unbounded while in office, a president who knows that he does not have to ultimately follow the law because there is really nothing more than, say, political accountability in terms of impeachment? I mean, we have amicus briefs here from Professor Lederman, for example, who says, a president would not be prohibited by statute from perjuring himself under oath about official matters, from corruptly altering, destroying, or concealing documents to prevent them from being used in an official proceeding, from suborning others to commit perjury, from bribing witnesses or public officials. And he goes on and on and on about the things that a president in office with the knowledge that they have no criminal accountability would do. I see that as a concern that is at least equal to the president being so worried about criminal prosecution that he, is a little bit limited in his ability to function. So can you talk about those competing concerns?
So, Justice Jackson, I think it would be a sea change to announce a sweeping rule of immunity that no president has had or has needed. I think we have also had a perfectly functioning system that has seen occasional episodes of presidential misconduct. The Nixon era is the paradigmatic one. The indictment in this case alleges another. For the most part, I believe that the legal regime and the constitutional regime that we have works, and to alter it poses more risks.
Thank you.
Thank you.
Thank you, counsel. Rebuttal, Mr. Sauer?
I have nothing further, Your Honor.
Thank you, counsel. Counsel, the case is submitted.
The Honorable Court is now adjourned until Thursday, the 9th of May at 10 o'clock.
Oh, are they about to rule? Are they about to rule? Bro, they're about to rule.
Really?
So look, Joe Biden, this January 6th, on the next election, if these us, say we call us liberals, if the Democrats came through and stormed the Capitol in the exact same way, would Joe Biden be held accountable? And he said he would have to be held accountable. And so they said, okay, we're moving. If Donald Trump gets held accountable or did this, would he be held accountable? And they argued
abroad by drone strike.
By Trump.
Could President Biden someday be charged with unlawfully inducing immigrants to enter the country illegally for his border policies? The answer to all these questions is no. Prosecuting the president for his official acts is an innovation with no foothold in history or tradition and incompatible with our constitutional structure. The original meaning of the executive vesting clause, the framers' understanding and intent, an unbroken historical tradition spanning 200 years, and policy considerations rooted in the separation of powers all counsel against it. I welcome the court's questions.
Mr. Sauer, to your last point, could you be more precise as to the source of this immunity?
The source of the immunity is principally rooted in the executive vesting clause of Article 2, Section 1.
And how does that happen?
The source of it, Justice Thomas, I think is, as you described in your separate opinion in Civitofsky, for example, that the executive vesting clause does not include only executive powers laid out explicitly therein, but encompasses all the powers that were originally understood to be included therein. And Marbury against Madison itself provides strong evidence this kind of immunity, a broad principle of immunity that protects the president's official acts from scrutiny, direct sitting in judgment, so to speak, of the Article 3 courts. That matches the original understanding of the executive.
So how exactly would we determine what an official act is?
I point the court to two cases for that. Obviously, Fitzgerald against Nixon is the best guidance that the court gives, where the court adopted the outer perimeter test. And this court engaged in analysis there that's very instructive here, where it looked at the level of specificity at which the acts are described. In that case, a civil case. Here it would be the indictment.
Well, what if you have, let's say, the official act is appointing ambassadors, and the president appoints a particular individual to a country, but it's in exchange for a bribe. Somebody says, I'll give you $1 million if I'm made the ambassador to whatever. How do you analyze that?
That, I think, would fall under this court's discussion in Brewster, where the court held with respect to legislative acts that bribery is not an official act, which also matches the common law background. So the way that this court in Brewster kind of sliced at the joint was to say accepting the bribe and the agreement to sex the bribe are not official acts. That's private conduct.
Okay, it's not.
Appointment would be essentially an unrestrictable power of this court that Congress couldn't directly regulate.
It's not, accepting the bribe isn't an official act, but appointing an ambassador is certainly within the official responsibilities of the president. So how does your official acts or the official acts order, boundary, come into play when it's going to be official, assuming that the president is innocent? But the whole question is whether he's going to be found innocent or guilty.
Again, I think Brewster and Johnson do address that, or very persuasively at least, in a slightly different context. Brewster and Johnson say the indictment has to be expunged of all the immune official acts. So there has to be determination what's official, what's not official.
Well, you expunge the official. You say, okay, we're prosecuting you because you accepted $1 million. They're supposed to not say what it's for, because the what's for part is within the president's official duties?
There has to be, we would say, independent source of evidence for that. And keep in mind that this indictment charges what this court has described as unrestrictable powers of the president. So the logical premise of this indictment is that Congress, by passing vague and general criminal statutes, has purported to directly regulate the president's exercise of things like the exercise of the appointment and removal power, things like his ability to speak directly to the American public, core exercises of his authority under the Recommendations Clause to recommend to Congress, members of Congress, the measures he thinks necessary and expedient. So you have an indictment in this case that goes right to the heartland of the president's powers, that alleges a whole series of official acts and tries to tie them together by saying, well, there's a private aim or a private purpose in that case. And that's a situation which, of course, could be alleged in virtually any indictment.
Counsel, it can be alleged, but it has to be proven. Malum in se is a concept long viewed as appropriate in law, that there's some things that are so fundamentally evil that they have to be protected against. Now, I think, and your answer below, I'm going to give you a chance to say if you stay by it. If the president decides that his rival is a corrupt person and he orders the military or orders someone to assassinate him, is that within his official acts that for which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
He could, and why? Because he's doing it for personal reasons. He's not doing it like President Obama is alleged to have done it, to protect the country from a terrorist. He's doing it for personal gain. And isn't that the nature of the allegations here? That he's not doing these acts in furtherance of an official responsibility. He's doing it for personal gain.
I agree with that characterization of the indictment, and that confirms immunity, because the characterization is that there's a series of official acts that were done for an unlawful.
No, because immunity says even if you did it for personal gain, we won't hold you responsible. How could that be?
That's an extremely strong doctrine in this court's case law in cases like Fitzgerald.
Well, we go back to Justice Thomas's question, which was, where does that come from? There are amici here who tell us that the founders actually talked about whether to grant immunity to the president. And in fact, they had state constitutions that granted some criminal immunity to governors. And yet, they didn't take it up. Instead, they pass an impeachment clause that basically says you can't remove the president from office except by a trial in the Senate.
I'll set one right here.
But you can impeach him after. So, or you can impose criminal liability. We would be creating a situation in which we would be saying, this is what you're asking us to say, which is that a president is entitled not to make a mistake.
Tinker! Chill.
More than that.
I'm sitting here listening to this fucking Supreme Court shit, bro.
Personal gain to use the trappings of his office. That's what you're trying to get us to hold, without facing criminal liability.
Your Honor, I would say three things in response to that. First, the doctrine that immunity does not turn on the allegedly improper motivation or purpose is something that this court has reaffirmed in at least 9 or 10
That's absolute immunity, but qualified immunity does say that whatever act you take has to be within what a reasonable person would do. I'm having a hard time thinking that creating false documents, that submitting false documents, that ordering the assassination of a rival, that accepting a bribe, and countless other laws that could be broken for personal gain, that anyone would say that it would be reasonable for a president or any public official to do that.
Your Honor, as this court said very persuasively in Fitzgerald, the allegation that this particular act would be done for an unlawful purpose or was unlawful could be made in every case. And therefore, if that were the doctrine, that the allegation of improper purpose is what deprives the objective acts of their immunity, then the immunity would have no purchase. And that's reflected in many of the court's cases.
Isn't the work, though, of the improper motive, at least in the absolute immunity context, to tell us what are official acts and what are not? I mean, I'd understood that even in the first of all, your ask is absolute immunity, isn't it? I mean,
That's our principal position.
That's your position is you want the same kind of doctrine that we've applied in other contexts when we say an official has absolute immunity. And my understanding is that when we say that, we mean for their official acts. Is that right?
Yes.
Okay, so any official acts, then in that world, the real decision-making from the court standpoint is whether or not something is an official act or not, correct?
That is an important determination by all means.
I mean, that's the determination in the absolute immunity world, because if you determine that it's an official act, then the principle is that you get immunity for it, correct?
That is correct.
All right, so my question, and I think the Chief Justice may have asked this at the beginning, is how do you determine what, or maybe Justice Thomas, how do you determine what is an official act? And when we're talking about the kinds of scenarios that Justice Sotomayor brought up, one could say that when the president is using the trappings of his office to achieve a personal gain, then he's actually not acting officially, even if the doctrine was absolute immunity. So what do you say about that?
Two things in response to that. First, to the last point, that allegation that this was really motivated by an improper private purpose could be made in every single case.
No, I understand that, but it would have to be made. I'm just trying to assess. Even if we had the doctrine of absolute immunity, that same allegation and the facts related to it would come in, because the person would be arguing that he was not acting in his official capacity. He wasn't doing something official. He was doing it personal, correct?
I agree. The objective, or I'm not sure I agree, but the point I would make in response to that is, in Fitzgerald against Nixon, this court emphasized that would result in an intrusive discussion or determination of the president's personal motives for every official act. And again, this is not just in the case of the presidency.
All right, can I just ask you another quick question before my colleagues take it over here? At the beginning of your